Hello, Michigan Realtors, and welcome back to the Letter of the Law. Today we turn our attention to inspection contingency clauses. Realtors and their clients often have questions about how these clauses work, most often when the contingency is deemed waived, and whether a seller can terminate a contract if a buyer requests a repair or a price adjustment. Unfortunately, there are no uniform rules when it comes to inspection clauses. The quote-unquote rules differ depending on the specific language in the specific inspection clause. Because there is no uniform law governing how contingency clauses work, and because clauses are drafted differently, the easiest way to explain the legal implications of an inspection contingency is to do so through a series of examples. Before we delve too far into the intricacies of inspection contingency clauses, it's important to understand exactly what these clauses are and what they do. An inspection contingency is simply contractual language within a buy-sell agreement that allows the buyer to perform an inspection of the property, typically through a certified home inspector, prior to closing. Now, depending on the specific language of the contract, this clause will allow the buyer to do one of two things if the inspector does in fact discover defects that the buyer finds unacceptable. First, the buyer can opt to cancel the entire contract. And second, the buyer may request that the seller repair the existing property defects prior to closing or reduce the purchase price accordingly. Again, the options available to the buyer depend on the specific language within the contract. Let's take a look at some sample clauses to see how the specific contract language can affect the transaction. Take this hypothetical situation. Sellers Smiths list their property for $100,000. The buyer, Browns, submit an offer which is accepted by the Smiths but subject to an inspection contingency, which reads like this. The buyer's offer is subject to a satisfactory inspection within 10 days. If the buyer is not satisfied with the results of the inspection, buyer may terminate this contract by providing written notice to the seller within this period. Failure to provide such timely notice shall constitute a waiver of this contingency. Now, let's say that the Browns obtain a timely inspection and learn that the roof needs repair. The Browns then propose an addendum to the Smiths indicating that they will proceed with the sale if they receive a credit against the purchase price or if Smiths repair the roof to the Browns' satisfaction prior to closing. Now here's the question. What happens if the Smiths don't agree to the addendum? Do the Browns still have the option of purchasing the home for $100,000? Or can the Smiths declare the contract terminated and sell the home to another buyer? Unfortunately, in this scenario, there is no clear answer. The Browns and the Smiths could find themselves in a legal dispute over the interpretation of the language of the inspection contingency clause, as well as the proposed addendum. Now, in an effort to avoid this situation, many inspection contingency clauses include language similar to the following. If the seller does not agree to make the requested repairs, the buyer shall have 3 days to waive the contingency and accept the property as is or to declare the contract null and void. With this type of inspection contingency language, the Browns can request that the Smiths make certain repairs while still maintaining the right to proceed forward with the buy-sell agreement if the Smiths decline to do so. By providing for this possibility in the buy-sell agreement at the outset, the Browns can request that the Smiths make repairs without disclosing the fact that they will close even if the Smiths do not agree to make the requested repairs. Other inspection contingency clauses are designed to discourage buyers from making repair requests unless they are, in fact, deal breakers. Now, these types of contingency clauses read something like this. In the event the buyer requests a modification to the buy-sell agreement based upon the results of the inspections, sellers may either agree to such modification or declare this buy-sell agreement null and void. Going back to our hypothetical, if repairing the roof is a make-or-break deal for the Browns, then requesting repairs in the face of this inspection clause is a good way to let the sellers know that the Browns are serious. However, in making the repair request, the Browns must be certain that this particular defect is a deal breaker, because there is a risk that the Smiths will choose to rescind the buy-sell agreement instead of making the repair. A seller who has a better backup offer may use this opportunity to terminate the first transaction. As you can see by these hypotheticals, the correct way of handling a contingency clause depends on how the clause is drafted. Inspection clauses in standard buy-sell forms used around the state vary greatly. Some clauses provide that the buyer's failure to provide notice during the inspection period constitutes a waiver. Other inspection clauses provide that a buyer's silence results in an automatic termination of the contract. Some, but not all, clauses allow buyers to waive their objections and proceed to close if the sellers will not make the requested repairs. Now, realtors should make sure to review the specific contract language before taking action and seek assistance of counsel if the issues become too complex or confusing. As usual, thank you for watching and providing such valuable suggestions for this video series. If you enjoy the Letter of the Law format, please visit ondemand.mirealtors.com for legal continuing education opportunities. And keep those suggestions coming to the email below. Thanks again, and we'll see you next time.